Mr. Apostolides is the latest in a line of applicants, some of whom have won, others have lost. But it's important we all understand the sea change that has occurred in Cyprus. We are engaging in a battle in courts, not in a battle involving guns, even though on the other side of the green line there are more than a few guns that need to go. So it's a terribly important point, and it's underlined by this case, and it's easily overlooked when we get bogged down in detail. But let's not forget that crucial point. It's also a sobering thought, in the light of the Apostolides case, that Mr. Apostolides lost his property, but he didn't lose his legal rights to property in 1974, and he was able to secure his rights in court. That is because the European Convention of Human Rights was established in 1950. The European Community was established in the late 1950s as a direct response, at least partly as a direct response to what the Germans had been doing to the Jews in Europe in the 1930s and the early 1940s. The Jews who lost their properties in the 30s and early 40s had no opportunity to go to court. The courts in Nazi Germany were corrupt. The laws of Nazi Germany wouldn't even allow them to go to court. So Mr. Apostolides' case has to be seen in that historical context as well. And it's a very important point that's, again, often overlooked by people in Cyprus. One is reminded when one sees Mr. Apostolides of the shrewd remark of Mahatma Gandhi, the Indian lawyer and pacifist leader whose life was ironically cut short by the bullet of an assassin. But according to Gandhi, a small body of determined spirits, fired by an unquenchable faith in their mission, can alter the course of history. And this is what has happened with Mr. Apostolides and before him, Didier Aloysiou. They have changed the course of history. I'm going to show you one simple example, and it's taken from the judgment of both the Court of Appeal and the European Court of Justice in the Apostolides case. I can just about remember the invasion, and in the aftermath we were being told by the Turks this was a peace operation. It wasn't an invasion, it was an intervention. It was justified under the Treaty of Guarantee, and so on. We're also familiar, and this is where I'm going to engage in a little bit of gentle criticism of our beloved Foreign Office, we're all also familiar with the various euphemisms employed by the Foreign Office to describe the invasion and occupation of Cyprus. In public, British ministers don't use those naughty words. And I can imagine that Sir Humphrey character in Whitehall telling the minister, you mustn't use those words, they'll offend the Turks. You must use phrases such as the events of 1974, the situation since 1974, the division of Cyprus since 1974, neutral terms, Minister. And that's what you see in Hansard, if you read Hansard, or in Parliament if you go down to see our beloved parliamentarians in action. By contrast with the lexicon of Sir Humphrey that we see employed in Parliament, our judges are not constrained by political considerations or the need to appease foreign powers. Thus, in the case of Apostolides, the courts were quite clear. In 1974, the Turkish army invaded the Republic of Cyprus. That was the phrase used by the Court of Appeal here in London. The European Court of Justice said that Turkey carried out an invasion of the Republic. The military action, according to both courts, resulted in the northern areas being occupied. These aren't words that trip off the tongue of British ministers, but they are words that trip off the tongue and are set down in writing in judicial decisions. Even when the High Court here in London found in favour of Mr. and Mrs. Orams at first instance, Mr. Justice Jack, the High Court judge, was in no doubt as to the character of what happened in 1974. He described the action of Turkey as an invasion. Turkey invaded the Republic, an action which resulted in, quote, the effective expulsion of Greek Cypriots from much of the area that was occupied. These are the courts of the United Kingdom. We have a separation of powers. So when we look at the events of 74, we can can safely say, so far as our English courts are concerned, occurred was an invasion resulting in an occupation. Why did Judges use those words? Because they signify the reality, the legal and the factual reality that Turkey engaged in a use of armed force in breach of the United Nations Charter, in breach of the Treaty of Guarantee, and in breach of various other international instruments, including the European Convention of Human Rights, the Geneva Conventions, and other instruments. Most of those, with the exception of the Treaty of Guarantee, were introduced in Europe thanks to the Foreign Office and its advisors back in the late 40s. They were introduced to deal with and prohibit the behaviour carried out by Germany and Italy during the 30s and early 40s. The United Kingdom, for all of its faults, and notwithstanding its participation in what I regard as the illegal invasion of Iraq, notwithstanding all of that, the United Kingdom was a champion of the rule of law and its establishment after the Second World War. And the activities engaged in by Turkey back in the 70s and the subsequent occupation are exactly the type of activities that the Germans were carrying out in a conceptual sense in Europe during the 30s. Germany was invading and occupying territory, flushing out the civilian population, and then they were colonising the territory under occupation with Germans in exercise of the policy of Lebensraum. And what the Germans also did was they established puppet regimes and property boards to provide a sort of figment of legitimacy to what they were doing. And our Foreign Office in the 40s under Ernie Bevin came along and said, no, this conduct has to stop. And Ed Bevin built a wonderful coalition, including Soviet Russia, and we have these instruments of international law, the UN Charter and the European Convention of Human Rights, which clamped down on exactly the type of conduct which Turkey perpetrated in 1974 and which it continues to perpetrate today with reference to the occupation and the colonisation of the occupied north. Let me move on and now just say a few words about lawyers, because this is becoming a big issue in Cyprus in the light of this Dimopoulos case at the European Court of Human Rights. Earlier this week, the Cyprus Mail carried an editorial with the wonderful title, "We must keep lawyers away from the Cyprus problem." Well, there are four of us up here at the moment, but we're refusing to counter what the Cyprus Mail is saying, as you can see. This is what the Cyprus Mail argued. It's time, it's a typical tub-thumping editorial, it's time that people with a broader vision, people capable of seeing beyond the sterile, legalistic discourse imposed by lawyers to try to wrest control away from the legal profession, which has caused more harm than good to the efforts to find a settlement. We cannot carry on treating a political problem in need of a political solution as a legal dispute, because it suits the island's lawyers. They have been milking the cow of the Cyprus problem for far too long. And every night when I watch Rick, well, I don't watch it every night because I'd go mad if I did, on the occasion I watch Rick, this is the argument. Too many lawyers, we have a political problem in need of a political settlement. What did we see earlier this week in the United States, ladies and gentlemen? President Obama couldn't resolve a political problem relating to healthcare without a political agreement, which is constitutionally permitted, drafted by lawyers, enshrined in legislation, and enforceable in court. The separation of powers demands no less. You need lawyers. You need legal agreements. Political agreements are worthless in the absence of them being legally binding. And as I was taught, and as I now teach my students, and there are a few here this evening, welcome to them. As I was taught and as I teach my students, law and politics form two sides of the same coin. Politics cannot be divorced from law, and although judges must remain independent and impartial, law cannot be understood in isolation of politics.